Hey everyone, Harry here to talk about Judge Tanya Chutkan's denial of Trump's motion to recuse her. So recall Trump had lobbed in a motion saying Chutkan had made these statements at the sentencing of a couple of the January 6th defendants, which to his view evinced bias against him. One statement, the much stronger of the two, said something like, while the person who orchestrated it all remains at large. And so the claim was this showed that that Chutkan believed that Trump was already had prejudged as the responsible party. And, at least one of those statements in isolation seemed like, that seems a little bit problematic, but the United States' response, I think, put it in the proper context, and that's the one that Judge Chutkan, in a 20-page opinion, reinforced. So when judges there's a distinction when it comes to recusal between extrajudicial statements, like stray statements in a speech or whatever, and judicial statements from the bench, which are nearly always going to be appropriate in the sense of, the better way to put it is, nearly never will be a proper basis for impeachment. And that's because it's what you expect judges to do. They're sort of the arbiters for society, and they're getting the statements all kind of together and explaining them to the defendant. So Chutkan, in her opinion, goes through the two supposedly prejudice showing statements and explains, look, these are in the context of sentencings when the defendants were making exactly the argument that she's addressing in her statements to them, that, look, why should they have such long sentences when other January 6th defendants who are more culpable don't get as much, and when the impresario of the whole operation, being Donald Trump, doesn't get much either. So that because those were on the bench, they already have this very high burden. And she went through and methodically applied the law. No sort of umbrage or anything like that. Just one foot in front of the other, and said this just doesn't cut it for a case of impeachment. And Trump's lawyers protested after, but it's a pretty solid ruling. They can try to make a emergency motion to the Court of Appeals. Don't see that succeeding. And I think part of what's going on here, this is the pretrial period when defendants will throw up a lot of different motions, try things that have very remote chances of success, but they hope might give some prospects for appeal on the other side of a conviction. So maybe combined with statements that Chutkan makes, say, during the trial, they can try to make a claim after a conviction, should that occur, that it was a mistake on her part, deserving of reversal of a conviction, not to have stepped aside. And that's part and parcel of a bunch of sort of throw against the wall and see what will stick kinds of motions. Now, as I said at the time, this one's not cost free, I think. Chutkan's a cool customer, experienced, knows better than to seem personally aggrieved. But John Lauro, Trump's lawyer, has now thrown up some really garbage arguments, including most recently in the argument for a gag order, making this whole big proclamation that it's all the Biden administration doing this, which is a political talking point, not a legal one, and has gotten crosswise with her a few times, and it can't endear him to her to be pushing for her to recuse. Nevertheless, all polite on the surface, and she just simply applies the law straightforwardly, says, look, this is a statement I made in court. Standard here is very high, and based on it, there's no legitimate claim that I need to recuse, or that a reasonable observer would say that I can't handle this trial impartially. So as expected, maybe a little bit of a hit on Lauro, and just be keeping in mind as some possibly increasingly crazy stuff comes down the pike, that it's just some combination of delaying, putting the government's resources, making them have to scramble and work, and then potentially hoping to set up something for an appellate issue on the other side. And having handled cases starting from that point, you never know what might look like potentially promising on appeal. So just something that a trial team will do now is, try to throw up some stuff with that, eventual vista in mind of a post-conviction appeal. So there you have it. End of the road there. I think Trump could try an extraordinary motion. Don't expect the DC Circuit to go with it. And now Chutkan moves into the all-important gag order. Trump has a few days to file a final brief, and then maybe she'll have a hearing. Maybe she'll just issue a ruling, but that's going to be a very telling encounter, including not just what she'll do, but whether she will, in addition, have order Trump, in and give some kind of personal admonition. So that's the next thing to stay tuned for in Judge Tanya Chutkan's court. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.